In this lesson, what I want to do is talk about the incorporation of contractual terms. What does this mean? How do I explain it? And what can we glean from this particular area of the law? All of which are questions we're going to explore in this lesson. The previous lesson took an introduction to contractual terms. We made the distinction between puffs, representations, and terms. The idea here of a puff was something of for the most part, we could make it, it was akin to, shall we say, a marketing slogan, some kind of thing that doesn't really have any kind of legal obligation attached to it, owing to the fact that it is just simply a statement of advertising, if you will. So the advert that we used as an example of this was Red Bull gives you wings. Now, of course, Red Bull doesn't actually give you wings. You couldn't sue Red Bull on the basis that you drank one of their energy drinks and that I didn't get given wings. Therefore, there's a breach of contract here. That's not how it would work. Representations, we noted, were a little bit more serious. They were statements or they were information, shall we say, given about a particular product or a particular service that induces a person to contract. So if I was told about the quality of a product, and I was told this, that, and the other about the quality of this product, and that information causes me to want to buy the product and enter into a contract for the purchase of the product, and then it turns out that that representation was false. It was not actually what the representation said it was. Then this would represent something of me being induced into a contract under false pretenses. And so the result of this is often likely to be able to get some kind of remedy in the basis of misrepresentation. But it is interesting here that representations are a little bit more serious than puffs. The final of which we were talking about was this idea of terms, the terms of a contract. The terms of a contract are the specific things that are in the contract itself, either expressly stated in a clause or implied through the contract itself. And these, of course, if you were to breach a term of a contract, the person would actually be able to sue for breach of contract. This lesson is going to talk about how one is able to determine which pre-contractual statements are kept as representations and puffs and which are incorporated into the terms of the contract itself. So if we go through the arduous process of a potentially lengthy negotiation between different parties in relation to contracts, and we find ourselves in the position where we have made lots of different statements, we've made lots of different representations, some of which may or may not enter into the contract itself, we are now asking the question, well, how do we determine? How can I determine which pre-contractual statements are kept as representations and which ones are not? Well, the incorporation of terms is an interesting element within the law of contracts. When it comes to which statements are incorporated into the terms of the contracts, the courts will often look at a number of considerations, a great many different considerations. For example, what are the intentions of the parties in the contract in the first place? That's an important question that needs to be asked. What did the people who were creating the contract intend? If there was clearly an intention that something be incorporated into the contract, then arguing that it should merely stay as a representation is probably not going to slide very, very easily. Now, given the difficulty examining the intention of parties, as well as all the other considerations that need to be ascertained, the courts have been able to develop a number of tests and procedures for examining the incorporation of terms into a contract. And I will refer us firstly to the case from 1976 of J. Evans and Son Portsmouth Limited. In this case, an agreement had been made between the parties for the shipping of products into the United Kingdom. The contract itself was in writing, and there was a clause within the contract which gave the transporters a certain amount of discretion in respect of, quote, the procedure to be followed in the handling and transportation of the goods. So the handling and transportation of the goods was something that the people who were actually doing the transporting had a certain amount of discretion over. They weren't going to control every single element of their job. And this was in the contract. This was a clause that was in the contract. In addition to this term that was clearly stated in writing, the parties had also come to an oral agreement that they wanted their product to be transported below deck. This was something, however, that did not happen. So you sort of have a bit of a clashing of terms, if you will. Not necessarily a complete contradiction of terms. They still had discretion to in terms of the procedure and the handling of transportation. But they said, "Can we have our goods transported below deck, please?" And this was an agreement that they actually said yes to. We will transport your goods below deck. Because the items shipped were above deck, the container would fall off and be lost overboard. Of course, not very good. The claimants then would sue on the basis that the defendants had breached their contract in terms of carriage. So this is quite interesting. They didn't just sue on the basis that they lost the goods themselves, which they may or may not have had a successful claim in, but they sued on the specific point that they had breached a term of the contract through this little oral agreement that was had. Now, the question was this oral agreement incorporated into the contract such that it represented a term that was as valid and as gold standard as the term that was actually in the contract, which gave the procedure to allowed the procedure to be followed in the handling and transportation of the goods in terms of the discretion that they gave to the defendants. It was held that the oral agreement which was made between the parties, despite not being in writing expressly, was incorporated into the terms of the contract. The courts took an approach of examining the holistic set of circumstances as well as the evidence, rather than just looking at what was literally written down. They looked at the entire circumstances, all of the situation, everything that was being spoken about, and they came to the conclusion that yes, it was clearly the intention of the parties to have the goods below deck. It was clearly agreed upon that this would be the case, something they failed to do, and the result of which led to a breach of contract. When we think about written terms, for the most part, when we are looking at what is incorporated into a contract, the strongest indication that something has been made into a contract is if it is actually written in the contract. That is almost that is a silver bullet in terms of argument that something is being put into a contract. If it actually has been put into the contract, it is almost tautological. And so this is something that I'm not going to spend much time thinking about for the most part, given the fact that when we have written terms, they're incorporated into the contract. It is often either terms that have been put in writing that are separate to a contract, or things like oral agreements that need to be incorporated into a contract as well as implied terms which are implied into the contract, all of which we'll get to in future lessons' time.